Hello my lovies, welcome to my channel. My name is Connie aka Coco. Guys, for those who are with me, still with me, thank you so very much. And guys, for the new ones, welcome. Guys, please like, subscribe and follow and comment in the comment section. Guys, in today's topic, I'll be talking about my favorite, which involves my work. I'll be talking about bail application, guys. So what qualifies me to talk about this bail? If you've seen my videos before, you would have seen that I was I'm a former employee of the Department of Justice. I used to be a court interpreter. I interpreted in criminal and civil court. And also I got my LLB degree. I did my articles. I wrote my board exam. At this moment, I'm in the process of doing my admission, which I will take you along with me when I am admitted as an attorney of the High Court finally. So without any further ado, let's get into it. I have made notes. And also I've done this practically and I've interpreted, so I know what I'm talking about. So there are three types of bails. We have a police bail. A police bail will be done for offenses which are under Part 2 and Part 3 of Schedule 2 offenses. Those would be like your theft, under 2,500, exceeding the speed limit. That one, the police has a discretion to give you bail on them. Obviously, they would have done the necessary checks to check whether your address is verified and then whether you have previous convictions and etc. Then they have the discretion to give you bail. Then we have your prosecutorial bail. What that means is that you would then be given bail at the police station or wherever at the police station before your 48 hours of being brought to court. That would be done at the police station before you are brought to court. But the person who will be there, it will be a prosecutor. Why a prosecutor? It's because those offenses would be a bit more serious than the offenses that would allow a police officer to release you on bail. Guys, this will be a prosecutor authorized by the DPP to do such. What that prosecutor will also look into, they will look into whether you are traceable, your address is verified, and whether you will not evade trial. They would look at such things. Those offenses are not as serious, are more serious than the ones where the police officers is allowed. Those are your offenses such as assault with the intention to cause grievous bodily harm, theft, fraud, not exceeding 20,000, exceeding the speed limit, and etc. Those are the offenses that a prosecutor will then come to the police station to do a bail at the police station before you are brought to court. But you will then have to present yourself to court. You will be one to appear at court on whichever date that will be first available for the court to hear you. Now, we also have Schedule 1 and Schedule 5 applications. Now, this Schedule 1, it's also minor offenses, not so minor but not so serious offenses. What will happen, you will not have done a police bail, a prosecutorial bail, then now you will be before a court on your first appearance. Guys, I need to tell you, when I was doing articles, my first appearance, the magistrate asked me, address me on section 6011B. Guys, it is very important to know what is section 6011B. What that entails is that you address the magistrate after you have consulted with your client on whether they have previous conviction, whether they have pending cases, whether they have outstanding warrants, and also the legislation has amended to include whether they have any protection orders against them and whether they have been admitted in parole. Now, you need to address the court on that. And also you need to warn your client of the non-disclosure clause. That means you have to warn your client before you address the magistrate that whatever information they give you regarding that, it has to be true. If it's found that it's a lie, your client might, that is a criminal offense, your client might face direct imprisonment, a fine, or both direct imprisonment coupled with a fine. So when you address the magistrate on that, then you must have warned your client. It's very important because it might come out later in the SAP 69s that your client lied, that your client has previous convictions, and whereas they have lied, whereas they've said they do not have those. So it's very important that your client understand the non-disclosure consequence. Now, moving along, so what happens is there are Schedule 5 offenses, which would be your murder. Remember, circumstances also determine what kind of schedule will that crime fall under. Your murder, your sexual assaults, or those more serious crimes. But also, a Schedule 1 offense can then change to a Schedule 5 offense. How that happens is, if your client now says, no, I have a previous conviction and I have a pending conviction, and you find that the previous conviction is similar to the charge that your client is facing, or the pending is similar to what your client is facing, they will then have to do a Schedule 5 bail application. And you find that the offense itself does not fall under Schedule 5, but you find that the offense falls under Schedule 1, but however, you now have to do bail application on Schedule 5 because of your previous conviction or your pending cases that is similar to the case that you are facing. Now we come to Schedule 5 offense. How that moves from a Schedule 1 to a Schedule 5 is that if your client now says to you, during the questioning of previous convictions and pending cases, your client says to you, I have a previous conviction or I have a pending case, and you find that the previous conviction and the pending case are similar to the charge that your client is facing at that present moment, then you will then have to do a Schedule 5 bail application. Now, moving into a Schedule 5 bail application, what that means, it means that you have to show the court that it will be in the interest of justice for your client to be released on bail. This can be done using an affidavit or viva voce evidence with your client under oath and give evidence. Now, what would your affidavit entail? Your affidavit will entail the name of your client. You will have where the court is sitting and all that bail application. Your client, your client and the state. Then you will then have the names of the client. You have to let the court see, you have to humanize the person. How you do that, you place your client or the accused or the applicant's background on the affidavit. They have their personal details. You state their names, age, marital status, kids, dependents, educational background, their work, how much they earn, and also you have to include whether they have property, fixed property and immovable property. Why you have to include fixed properties and immovable property, I used to not understand, but now I understand that is used to also determine whether this person would evade trial. A person who has a fixed property is very unlikely that they would just abandon and evade trial and leave their fixed properties. Those are the things that the court considers also when coming to a decision on whether to grant bail or not to grant bail or not to grant bail. So you list the personal circumstances of your client, what they have, movable and immovable properties that they possess. You also place their background, personal background, marital state. That personal background will include name, marital status, age, so whether they are South African citizens or not South African citizens. If they are not South African citizens, you'll have to include their passport numbers and whether they are legal in the country. That is very important also. Now, after you have done that and you have put down the background of your client or the accused, then you move to the more crucial. Now, you will have to then show the court that it will be in the interest of justice to release your client on bail. Now, what that entails is that you must tell the court that if your client is released on bail, they will not endanger the safety or of the public or any person or commit any offense. They will not evade trial. They will not attempt to influence or intimidate witnesses or conceal or destroy evidence. They will not undermine or jeopardize the functioning and objectives of the criminal justice system. That is it's very important. Further, you can also attach that the court may impose bail conditions. Now, I've seen in exams for both, they will then ask what bail conditions may a court impose. The bail conditions that normally are imposed, it will be you to report at your nearest police station on certain days at certain times, to not intimidate or to try and communicate with the witness directly or indirectly. Those are the common bail conditions, but further conditions may be imposed by the magistrate dealing with the matter depending on the circumstances. Remember, each case is just on its own merits. So now, what will also happen, you will also need to tell the court that the money available for bail is this much. You need to give the court that. The court will also consider that. The court has a discretion to give bail or not to give bail. Now, after you have submitted your affidavit and the state has also submitted their affidavit, they will then ask you if you have any further address. If you have further address, maybe to speak on the strength of the state case, your intentions of how you're going to plead, you may do so. But if you do not, you can also only rely on the affidavit. Please, your affidavit has to be as detailed as possible. You have to include everything that you feel that is important to the case and to the court to know, in order to enable the court to rule in your favor. Also, what happens at a bail application is that sometimes the magistrate might need clarity from the investigating officer regarding certain issues. When that happens, the rules of examination of evidence will follow. The magistrate will ask whatever that they need clarity on from the investigating officer under oath. The state will be given an opportunity to ask any questions based on what the magistrate had already asked. Nothing new, based on only what the magistrate was seeking clarity on. And the defense will also be given the opportunity to ask the investigating officer a further question based on what the magistrate needed clarity on. And it will end there, and the court will give its discretion. Also, if you decide not to take the route of handing in an affidavit, and you decide that you are going to lead your client to give viva voce evidence, what is on the affidavit, it's same thing that you will be doing when you giving your client decides to give a viva voce evidence. What will happen, your client will be in the witness box. They will be in the witness box. They will be under oath or an affirmation. You will then lead your client accordingly to how you would have written in the affidavit. Their personal background, how they intend to plead on the case, Also, whether they will evade trial, they will jeopardize, they will intimidate witnesses. Those kind of questions are what you will ask your client. Also, because now we are dealing with viva voce evidence and your client is under oath giving evidence, same rules apply. The prosecutor has the right to cross-examine the applicant. And also the magistrate, if clarity is needed, they will then cross-examine your client. So most of the time, I personally prefer to give evidence on paper with an affidavit. So once that is done, the court has a discretion to give bail or not to give bail, and they will attach the necessary condition if the court deems fit to attach conditions. So guys, the reason I did this on bail application, guys, I've seen that in the past exams on criminal law, paper 1, they would ask less questions. But I saw on the last paper that was written in March that there were criminal law questions, which were a lot. They counted for about 25 marks, if I'm not mistaken. Guys, so 25 marks, it's a lot. With criminal law, you need to understand. You need to understand. When you have an understanding, it will be better if you get a question paper and it says draft a bail application, Schedule 5 bail application. Then you know that there was a video that I watched that explains Schedule 5 formal bail application. What are the things that you include in your affidavit, which is your background, the background of your client, the background of your clients, and then that part that speaks to, will it be in the interest of justice for your client to be released? So once you understand that, all is good. And also, guys, because I stay in the location, so you would see people not understanding and asking, this person did this and this, why did the court grant him bail? At a bail stage, it's not a test on whether you are guilty or not guilty. At the bail stage, according to our constitution, you are assumed innocent till proven guilty. So when you are applying for bail at that time, standing in front of that magistrate, you are assumed to be innocent till proven guilty. However, there is prima facie evidence that has brought you before court. That does not mean that you are guilty. You are only guilty once you have been taken to the trial court and a trial is conducted and the state proves its case beyond reasonable doubt. Then only then we will say you are guilty. But before you are proven guilty beyond reasonable doubt, you are not guilty. And in bail, granting or not granting of bail does not mean that you are guilty. No. It just means that the court maybe made a finding that it will not be in the interest of justice. If it's a Schedule 6, maybe the court made a finding that there are no exceptional circumstances that permits the court to release you on bail. Bail application does not determine whether you are guilty or not guilty. That is very important to understand, and that is also very important to also relay in our community, that when they see a person released maybe after an accusation of a heinous crime, that does not mean that it ends there. No, they will still have to attend trial in order to prove their innocence and in order for the state to prove their guilt beyond reasonable doubt. Guys, I will in the next video go in depth regarding a Schedule 6 bail application. Also, for those who are writing exams, I will then in the link attach a pro forma of a formal bail affidavit application. I will attach that, and then you can look at it. If you want to use it, you can edit it however way which will suit the circumstances of your client. Guys, I know this road is very difficult. I was once there. I was once a candidate attorney, and I know right now people are preparing for exams. Please capitalize on this video so that you can improve your marks, know about bail and what bail entails. Guys, I love you so much. Thank you for following. Those who are new, welcome. Guys, subscribe, follow, and like. Help this girl grow. And look out for my next video on Schedule 6 bail application. Thank you.